Please, and also introduce yourself for the record and also who you represent.
Thank you, Mr. Chairman. My name is J. Fred Hart Jr. I'm an attorney in Little Rock. I'm just representing Truth and Justice as I signed up. I happen to believe very deeply in this bill. I'm not here on behalf of any organization. Since I haven't appeared before the committee before, I'll introduce myself. My name again is Fred Hart. I'm an attorney here in Little Rock. I graduated from Catholic High in 1967 and the University of Dallas in 1971 in the Arkansas Law School, Fayetteville in 75. My family is from Arkansas. My father grew up in Little Rock and my mother grew up in Conway County, so I have some roots here. Mr. Chairman, I will speak very deeply on behalf of the bill. There's been a lot of misinformation here in my judgment this morning. I've heard from Mr. Mosley and Mr. Whitmire that we don't need this bill because the protection already exists. What I have not heard from Mr. Mosley and Mr. Whitmire is a decision from the Arkansas Supreme Court granting the same protection that this bill grants. If they have that case, I'd like to hear it. I'm not personally familiar with it. In fact, at the end of his testimony, Mr. Whitmire stated that the Arkansas constitutional protections are largely dormant. I don't understand how you can have a provision that's dormant at the same time speak with assurance that it grants the same protection that this bill grants. But even if Mr. Mosley and Mr. Whitmire could cite a case, it could always be reversed. The Arkansas Supreme Court has been known to reverse itself, as has other courts. This legislation would lock this into place. Mr. Mosley referred to people claiming that the right to possess marijuana is some kind of constitutional right, particularly in criminal cases. Mr. Chairman, I don't know if Mr. Mosley has any criminal experience. I do. When I lived in Fort Smith, I spent 2 years in the Sebastian County Public Defender's Office, and I raised a lot of creative defenses, as did our office. Defenses along the same lines, and they generally didn't go very far. And the reason is because Judge Don Langston and Judge John Holland and the Sebastian County juries had the sense to see through our arguments. So at the end of the day, Mr. Chairman, I think you're simply going to have to trust that the judges have the sense to be able to separate out the wheat from the chaff. We also heard from Mr. Whitmire there's going to be a flood of litigation descending upon the counties and the cities and the states. First of all, as has been noted by the committee, where is the record in the other states of this tsunami of litigation? Where is it? If it's true in Arkansas, it would be true in the other states. I'm not personally familiar with that. But again, and Mr. Chairman, I don't mean to engage in that humbling arguments. I don't know if Mr. Whitmire has ever been in the private practice of law, but let me tell you, somebody who has, that in general, attorneys in the private practice of law are looking for some way to get paid, like other businessmen or other entrepreneurs. And there is a tremendous discipline in not taking frivolous cases from the standpoint that you're going to end up spending a lot of your time and quite possibly and typically spending money out of your own pocket because your clients not only don't have the money to pay an attorney's fee, they don't have the money to pay the out-of-pocket expenses. And so typically in these kind of cases, the attorney is investing his or her time and probably some of their money to finance the case. And so I would urge to the committee that this is a powerful discipline in cutting down on frivolous litigation. Does it exist? Sure it does. And as the chairman pointed out, Rule 11 deals with that. You can address attorneys in filing frivolous lawsuits. It's already there. There will be frivolous lawsuits. There already have been. There's no way to protect it. Unless you want, ladies and gentlemen, to just abolish the courts, you could do that. I'm not advocating that, but you could do that. That would eliminate frivolous lawsuits. Unfortunately, the downside would undoubtedly be worse than the upside. Let me conclude with one other thing, ladies and gentlemen. Representative House made a reference to having relatives who are Jehovah's Witnesses. And I'd like to talk just briefly about some real history, the history we didn't hear from Mr. Mosley and Mr. Whitmire. And because there is, in this whole idea of religious freedom, a series of cases, and some of you may recall going back. In fact, this is the original religious freedom cases had to deal with blood transfusions. And some time ago, for reasons that I don't now recall, I decided to do some research on this, And I came up with a couple of fascinating ALR annotations, and as attorneys know, ALR is sort of the gold standard of research. And it is a fascinating question. The Jehovah's Witnesses and some other groups have religious objections to blood transfusions because they view it as a violation of the Levitical prohibition on drinking blood. And it's a very strong prohibition. It's a very strong, important tenet of their case. Now, the other side of the coin, obviously, is that blood transfusions for the general public are fairly common. They're not particularly expensive. They're not particularly painful. They're not the sort of things that and they're absolutely efficacious. In fact, typically they're life-saving. It's a matter of life and death. And so this is a case I would urge the committee members where you have some real traction. You want to talk about the real debate about religious liberty, and when it really counts. These kind of cases are the ones that where the rubber really meets the road. And back then when I did this research, the central case seemed to be, as I recall, the application of the directors of Georgetown University, which was a D.C. Court of Appeals case, which is the highest apparently at that time that these cases had gone. Actually in the District of Columbia Court of Appeals, because in the District of Columbia, the federal courts or the local courts, and they actually ruled against the individual. Now, there are cases going both ways. There are cases in which the courts have allowed the person to refuse a blood transfusion. There are cases, as in the application of the directors of Georgetown University, where they ordered Georgetown University Hospital to administer blood transfusion against I think it was a woman's will. So, ladies and gentlemen, these are the real issues. And why am I telling you this? Because I think if you read these cases, you're not going to read that, particularly the Georgetown case, what you see is a reasoned, dispassionate, and very intense analysis by the judges of the balancing interest, and where it really is compelling, where you really do have some traction. And I would suggest to you that you're going to see the same sort of thing on the part of the judiciary in Arkansas. That they're not going to take this thing frivolously. The argument that I don't have to pay my taxes because I'm the Church of Steve or whatever. I mean, we have judges who, for the most part, have a lot of common sense. And although the chairman is out, I would just like to say for the record that I'm a great admirer of the 8th Circuit Court of Appeals, especially the members from the state of Arkansas. But anyway.
We'll make sure that's duly noted and he's aware of that.
Thank you, Mr. Chairman. But anyway, ladies and gentlemen, yes, you can create all kinds of imaginary horribles. We could, Representative Manager could come in with a bill that's like a phone book, all kinds of exceptions, and then we would hear complaining about it's too burdensome. I think this is a reasonable and a correct balance of an important right. Religion matters, ladies and gentlemen. The free exercise of religion in our tradition is very important. And if Mr. Whitmire's counties or Mr. Mosley cities are truly violating the important fundamental rights of individuals, then, ladies and gentlemen, they should be sued. That's why you have the courts. So anyway, thank you, Mr. Chairman.